Perfect. So it's my pleasure to introduce our speaker, Solange, who is a lawyer and partner at Taylor McCuffrey with extensive experience in estate planning and estate administration law. She also has delivered numerous presentations to clients here at ANO, and today she'll be discussing key topics such as estate planning, powers of attorney, healthcare directives, and will. And we also would like to do a land acknowledgement. So, in the spirit of reconciliation, we acknowledge that Manitoba is in the traditional lands of the Cree, Ojibwe, Ojibwe, Dakota, and Dene people, and the homeland of the Métis Nation, and we are on Treaty 1 territory. Now, please join me in welcoming Solange.
Thank you very much. Okay, welcome everyone. In preparing this presentation, I've wasn't too sure who would be attending the presentation today. So it is, there are some portions of the presentation that will be more relevant to healthcare providers and others to support providers like family and things like that. Having said that, I'm happy to answer any of your questions at the end of the presentation. This presentation is not going to go into detail on how to make a power of attorney, how to make a will, but more about things that you should be considering when you're dealing with someone that has some either a lack of planning or bad planning or what have you, and how to deal with those questions. So I'm going to get right into it. So the first and the big one is mental capacity. Okay, so what is mental capacity? Mental capacity is the touchstone of every legal act. It touches on every act that a person may engage in. So mental capacity gives rise to the ability for someone to freely give consent to something. So examples, you have to have the right capacity to make a power of attorney or the capacity to instruct on healthcare decisions and things like that. So every act has a different test when it comes to capacity. So depending on your role, dealing with the person, it makes sense depending on what it is the person needs to do or should be doing. I'm going to call the person, that just means the person that you're caring for, okay? Or yes, that person. They have to be able to understand what they're doing in order to do it. Otherwise, it may not be valid. It may be fraudulent. There's all kinds of issues that come up. So, as an example, I'm sorry. I thought did you guys have this in front of you 2 minutes ago? No? Okay, so the mental capacity is the ability of a person to make decisions. Okay, so this is what we just discussed. And the time that whether someone is able to make a decision or not is time specific. So somebody may have the ability to make medical decisions for themselves at 1 o'clock, but then are on such a heavy dose of drugs that at 2 o'clock they're not able to. But then maybe at 6 p.m. they are able to. So just because someone doesn't have capacity at one point in time doesn't mean that they do not have capacity as a general rule for everything. Okay, so as I said, capacity is task specific. So this list that you have here, there are specific legal written tests of capacity. Some are in legislation, so in laws, and some of them are set out in the common law, so judges' decisions as to whether someone has the capacity required to do something. What is important here is if you're asked to provide evidence, that you be honest and forthright. And if you have a concern, I would suggest that you keep a record, write it down so that if it comes up later, there's evidence as to what your concern was and why it was. So I tried to be cute here. Oh no, I don't think that the person I care for is able to make their own healthcare decisions. What should I do? Okay, well, first thing you have to know is that there is a presumption at law that an adult has mental capacity to make their own decisions. Okay, so that's a presumption. You're presumed to be able to make your own medical decisions. Um, there is a law in Manitoba called the Vulnerable Persons Living with a Mental Disability Act, and that mostly applies to people that have a mental disability that existed prior to age 18. But they do set out a test there as setting out whether someone has capacity to make medical and personal care decisions on their own. And it's instructive for all other things as well. So I'm going to read it to you. So a person is capable of making personal care decisions if the following conditions are met. Number one, the person is able to understand information that is relevant to making a decision concerning his or her own care or his or her own physical, emotional, psychological, residential, educational, vocational, or social needs or similar needs. Okay, so is the person able to understand information relevant to making the decision? And then secondly, is the person able to appreciate the reasonable, foreseeable consequences of the decision or lack of decision? So you may have people that are or not able to make their own medical decisions depending on what kind of decision it is, right? There's like two extremes, right? Do you want some Tylenol for that headache? And do you want to elect maid? Like those are two extreme decisions. The person may be able to decide whether or not they want some pain relief, but they may not be able to understand what is meant by medical assistance in dying. So those factors are usually considered by the healthcare profession and by the physicians involved. Okay. I have had clients that have not been able to communicate other than by moving their eyes up and down, side to side, yes or no. And that was sufficient to be able to make their own healthcare decisions with the help of the medical staff that was there. Uh, so the first question again, how do you determine if a person is no longer able to make their own medical decisions? Do they understand all of the information relevant to making the decision? And are they able to appreciate the foreseeable consequences of their decision? And this is not something that needs to be, how can I say this? It's not this is subjective on the part of that person, not of you. So if you're a family member and you don't agree with what they're doing, it doesn't mean that they don't have the ability to make the decision. Okay. The person is able to make decisions as long as they understand those things. Okay, let's assume they don't have the capacity to make their own medical decisions. Say they have advanced dementia and they don't understand what's going on. Then the next question is, does the person have a healthcare directive? So there's another law in Manitoba, the Healthcare Directives Act, that allows someone to name who they would like to appoint to make medical decisions for them if they're not able to. That law also allows them to set out their healthcare wishes. So in Manitoba, every person over the age of 16 who is capable of making their own medical decisions, we looked at that test already, is able to make a healthcare directive. So the question is, do they understand what it is they're doing? Okay, and the decisions they have to make? And do they understand the foreseeable consequences of making that decision? So if they're able to do that, they can make a healthcare directive. And so that document will allow the person that they've named in the healthcare directive to make medical decisions for them if a situation were to arise in which they are unable to make that medical decision themselves. So if you're dealing with a situation where mom is in care and she wants X, but the daughter wants Y, okay, and the daughter is very forceful that no, mom needs to have Y, mom needs to have Y, it's up to the caregivers and I would suggest the physicians, just to cover, to protect yourselves, if you will, to determine whether or not you should be taking instructions from that patient, or whether you should be asking for a copy of the healthcare directive. Okay. So if I say wrong things because I don't work in the healthcare industry and someone wants to correct me, please do interrupt me and correct me. Okay. But that's the Healthcare Directives Act. And the Healthcare Directives Act also allows you to set out your wishes. And depending on how that is written, I know that doctors really hate having to interpret a healthcare directive. So mine give the discretion to the proxy, the person that's named in there, and not the doctor themselves. But it does happen that some healthcare directives tell the doctor to do this or do that. That's something that if you're in the healthcare, working in the healthcare system, let's say you're working with the WRHA or another regional health authority, you guys, I just learned this in the last 3-4 years. You guys have ethicists who are able to guide you through those questions. My understanding is that the Winnipeg Regional Health Authority has guidelines that it will follow in the absence of a healthcare directive. Okay, so that guideline, it's written and it sets out who will make medical decisions. And the first in line is the spouse or common law partner, followed by the children in order of seniority, then the grandchildren by seniority, I believe, then the parents, then the siblings, then the nieces, nephews, and then close friends, et cetera, et cetera. It doesn't mean that that person must make that decision, but if there's a medical decision that needs to be made and it needs to be made quickly, the WRHA, their guidelines, gives discretion to the physicians and to the care providers to take instructions from who they think is appropriate under the circumstance, ideally in this order. At the end of the day, the healthcare providers will not or should not take instructions that they feel will harm the person that is in their care. If the instructions of the proxy are being followed, and if they're in opposite, if they're in contradiction to what the healthcare directive says, if there is one. Okay, myself, I have clients all over the place when it comes to healthcare directives. Some put no directions, which is fine. Some go to the extreme on one end and say not only do not resuscitate, no heroic measures, comfort care, but also go as far as to saying, if I have advanced dementia, then I don't want to be treated for anything. Okay, let me die. If I don't want food, don't feed me. So that's one extreme. I have the other extreme as well. People who love life and want at all costs to be kept going. So those are, it's important for caregivers not to substitute what they think is right for what that person's wishes are, right? So that's often difficult, and it's a hard situation to be in. What I find is that the more information is in writing in a healthcare directive, the more that has been discussed with the doctor, the easier it will be for all people involved, whether they agree or not. If the directions are there, it's much harder to contest them or to argue about it. Now, what if you disagree with the person authorized to make medical decisions? Okay. If you're all mostly healthcare providers here, you will appreciate this. Be respectful, be patient. Whoever disagrees should be communicating their opinion calmly and being open to hearing other positions. And then if the person is still not happy with the medical decisions that are being made and they don't think they're being made in that person's best interest, then they can hire a lawyer to try to have the healthcare proxy removed. But they will need to provide evidence that the person is essentially harming um, the incapable person, that they're making decisions. Either it's neglect, either it's intentional harm. Um, the court is there to protect people and not to take sides in the family dispute. My phone is, I'm just going off script here for a second. My phone is ringing off the hook. When my phone is ringing, can you guys see who's calling?
No.
Excellent. Okay. So it's only distracting me. That's wonderful. So lawyers may or may not be able to help. Okay. It is appropriate for healthcare facilities to protect themselves and their staff. So if you are dealing with a family member that is not in agreement with what's going on, you do not need to intervene or that's not the right word. You are not required to take on that stress and abuse. I think that the best way to deal with it is to just give them avenues as to where they can go to get their grievances heard, whether that's just talking to a lawyer, talking to the court, talking to the, ideally to whoever's named as the healthcare proxy on the document. That should be the first go, but not everyone is acting reasonably in situations where their loved ones, parents, friends, spouses are in care and unable to make medical decisions on their own. You guys will know this. Not everyone acts reasonably in those circumstances. So just directing them to who may be able to address their concern is better than trying to do it on your own. Okay. Now, next subject. Oh no, I don't think that the person I care for has the capacity to make financial decisions on their own. What should I do? Okay. Oh, I'm sorry. Well, here's something you should not do. We had um, a session at Age and Opportunity a while ago, and a healthcare or a support person brought in an elderly client to make his power of attorney document. And he had no idea why he was there. He didn't know what a power of attorney document was or why he might need one. And he really had no clue. And I asked them, I told them that they can't, that I will not make a power of attorney for him because he didn't have the capacity to make one. And it was a stressful situation for the care provider because they strongly felt that one was required. So when this is going to be sound like a silly comment, but it's really not. It comes up over and over and over again. Even though people are very emotionally involved when it comes to medical decisions, they get more aggressively involved when it deals with money. Okay, and the court is more likely to make a decision or take a side when it comes to money. So if the person doesn't have is no longer able to um, make their own financial decisions, it's not up to you to make that decision. So to determine, here's the test. So to determine whether someone has capacity to manage property, that is set out also in the Vulnerable Persons Living with Mental Disabilities Act. And capacity to manage property considers the following criteria. Okay, is the person able to understand the information that's relevant to making decisions in the management of his or her property? Is the person able to appreciate, again, this is the same one, this foreseeable consequences of their decision or lack of making a decision? Ideally, before anyone steps in as attorney under a power of attorney without the express consent of a competent person, a competent donor, I'll call whoever made the power of attorney the donor. Ideally, they would get an opinion of incapacity made by a physician. Ideally, that physician is also the primary care doctor or someone involved regularly or occasionally enough with that person's care. Okay, just because a doctor has provided an opinion of capacity, someone is able or not to manage their own finances or personal care decisions or property decisions, it does not mean that the person is not able to make a will, is not able to make a healthcare directive, is not able to make a power of attorney. All of those tests are different. Okay, and it would be usually when a big legal question comes up, it's up to the lawyer to make that determination. And a good lawyer would have copious notes in their file regarding their assessment of capacity. I also wish to point out that it's very difficult for, it's very dangerous if you're the attorney named under a power of attorney document. So you're the person that has been named. It is, in my opinion, very dangerous for you to assume that the person doesn't have capacity just because they're doing things that you don't think they should. Okay? People are allowed to make stupid decisions. And so that comes up often enough. So it's important for you, if you are going to step in and start making financial decisions for this person, you have to understand that you will be liable for the decisions that you make. And certainly if a court deems that, you were specifically told not to do that and you stepped in and restricted that person's ability and their freedom to manage their own money. Okay, another issue. If one thing that is very difficult that I see in practice is where you've got possibly a loved one with, they may be having mental health issues, whether that's dementia or what have you. And they refuse to see a doctor, refuse to get help, refuse to be seen. Those are situations where if in my experience, and you guys can tell me if this is incorrect, but in my experience, this is where we would usually call the seniors mobile mental health crisis unit. And so they send out someone to do a health check and to make sure that the person is not a danger to themselves or in danger. Okay, they will not pick someone up or make a medical assessment just because of a call. But if that person is in danger to themselves, they may pick them up and bring them to a mental health ward in order to make a proper assessment. So here's what you, okay. So if the person has not signed the power of attorney document, what should you do? If a power of attorney document exists, you should contact the attorney named under that power of attorney document. If a power of attorney does not exist, then usually the care facility will arrange for discussions with the director of psychiatric services of the province, who's then able to appoint the public guardian and trustee to step in and make financial decisions for that person. In the alternative, the person's next of kin who is living in Manitoba can apply to the court for the right to make financial decisions for that person. That's called committeeship. However, I want you guys to note that a committee will need to pass their accounts at court on regular intervals. Most of the time, they're required to post a bond to the court. And they're also required to provide accounts to all of the other next of kin. Okay, sometimes this is costly. Sometimes it makes sense to do that, and sometimes it doesn't. So my understanding is it is the preference of um, the public guardian and trustee not to get involved if someone else is able to do it. However, if you are dealing with a client that does not have much wealth, it often makes more sense to have the public guardian and trustee act than to um, have a family member apply and be appointed and incur all these legal fees. Um, so this comment is more addressed towards family members um, or close friends. If the person does not have a power of attorney document and they now have dementia, they don't have the capacity really to make a decision or the memory or what have you, you should, oh, this is the next slide. Sorry, I'm seeing both here. You should not try to force that person to make a power of attorney document. Okay, if that happens, likely other family members will try to contest it or will aggressively try to get accounts, which is fine. It's important to be able to account. I have seen situations where daughter would bring mom to get her power of attorney done. And then the next week, son would find out, he would take mom to get a new power of attorney done. And this went on every week for about 3 months, different lawyers all around town. None of this is helpful to mom. None of it. And situations like that, in my opinion, mom does not have capacity to decide one way or another, and likely the public guardian and trustee or someone else should be appointed commentee for her. So we do see those kinds of situations. That includes the comment, do not go lawyer shopping. Ideally, if somebody, oh, I'm sorry, if somebody has a power of attorney in place and it doesn't seem like that power of attorney makes sense and you think that it should be updated or changed for whatever reason, and you think the person might have capacity or might want to do that, what you should really do is encourage them to go see the lawyer that made this document for them. And I would encourage that person to disclose any mental health issues that they're dealing with, disclose all of their family circumstances that affect their decision making, disclose their assets and how they own them and why they own them that way. The more information the lawyer has, the better the better the advice the person's going to get, but also the less likely it will be that the document can be contested in the future, or the validity of it can be contested in the future. Now, I didn't deal with this in this slide because I wasn't sure how many people intending would be healthcare providers and how many would be family members providing care. So I'm going to mention it anyways. It's a bit of a pet peeve of mine. Medical decisions are made by the proxy named under the healthcare directive. Okay. The power of attorney document has nothing to do with medical decisions. So if somebody's admitted to hospital and you're asking to see the power of attorney document, I hope that it's because you want contracts to be signed with the care facility and you want to talk to the person that is managing the purse strings. The attorney under a power of attorney is not the same as a healthcare proxy. There are two different pieces of legislation that deal with completely different things. And so medical decisions are made by the proxy named under the healthcare directive. Financial decisions are made and legal decisions are made by the attorney appointed under the power of attorney document. Unfortunately, there's a bit of a hole in Manitoba when it comes to personal care decisions. And that might be things like who a person can talk to and see, who can meet with the person and who can't. Um, Whether they're going to participate in this program or that program, there's kind of a hole there. Um, and so ideally, if the healthcare proxy and the attorney can agree, that's ideal. Um, if that's not the case, there isn't a tiebreaker there in Manitoba to specify who makes those decisions and who's entitled to make those decisions. So if you've got two people attending your facility and they're fighting about this should happen or that should happen, again, if you're able to get consensus and you feel that you want to work on that and do that, that's fine. But if they really can't agree and it gets combative, or if they're screaming and things like that, you can ask them to leave, and they can hire lawyers to help them deal with their disputes. Often, when someone is required to pay for advice, they're less likely to, how can I say this? When there's a fee attached to what they're trying to do, they may be a little more willing to bend on their position, okay, as opposed to taking a hard stance. I'm sure that a lot of you see hard stances. I've had disputes between two family members on healthcare decisions being made for mom, and one's bringing mom to get a new healthcare decision made, and they're going back and forth, changing her healthcare decisions, and all of it there's this big dispute about a urinary tract infection. Okay, poor mom, poor mom. This is a situation where you may not able to get a consensus from them. There are the issue is probably not the big issue is probably not related to the urinary tract infection. There is probably more there. Like, my sister doesn't respect me, or, oh, my sister's always pushy, or that's not something that you can fix. You don't need to try to fix that. If you can get, if you're able to get to a solution that advances the interests of your patient, then you're doing what you need to do. Oh no, I don't think that the person I care for has made a will. Or I don't think that the person's will does what they want. Okay, so the first question is, can the person still make a will? The test, the legal test for making a will is it's a much harder standard to meet than the other tests. So in order to be able to make a will or to revoke a will, the testator needs to understand the nature and extent of their property, the persons who are the natural objects of their bounty. They need to understand the testamentary provisions they are making. So what does their will actually say? What is the effect of what it says? In addition to that, they need to appreciate all of these factors in relation with each other and form an orderly desire to dispose of their property. Okay, that's the test. When a will is made, meeting all the formalities of the Wills Act, okay, and after it's been read over by the testator, who appears to understand it, there is a general presumption that the testator knew and approved of the contents of their will and had the capacity to make it. However, that's a presumption which anyone can provide evidence to show the contrary, okay, that this wasn't the case. So sometimes that evidence is, evidence of dementia, or evidence that somebody forced them to do this, or that, Joe, who's living with mom, will stop feeding her or stop letting her use the phone if she doesn't do a will. Things, there's all kinds of funny things that happen, but that is the legal test. And the it's a really hard determination to make whether or not someone has the capacity to make a will, certainly when there are mental health issues. So this quote here comes from a case. I don't remember which one here. If a person has been adjudged incapable of managing his or her own affairs, it does not necessarily preclude that person from having the sufficient mental capacity to make a will. Okay, so you can have someone that um, has no has no control over their spending, right? But that doesn't mean that they don't know what they have and who they want to leave it to. So those are two different tests. Um, ideally, um, sorry, I'm looking in my notes and I'm getting confused here. But ideally, uh, if someone's not sure whether or not the person is able to make a will, all of the information regarding the mental health concerns should be shared with the lawyer so that they can be aware of the issue and make dig deeper into the information and spend more time with the client in order to ensure that in this situation they meet those criterias and that there's notes in the file in case the will is ever contested. So I go back to these questions. Can the person still make a will? Okay. Hard no's and hard yeses are easy to identify. It's those middle grounds that are harder to identify, and they're not situations where you should be making that decision. The lawyer should be making that decision with all of the information that's provided. The second one is, does the person want to change their will? Just because you think the person should change their will, it doesn't mean that they want to. And often if somebody is in a vulnerable circumstance, situation, like they're living with you, you're taking care of them, and or you're a care provider and you think they should leave you something or what have you, none of that is appropriate. If the person decides that they want to change their will and they would like your help in just arranging a meeting with a lawyer, ideally they're the lawyer that they did their prior will or a lawyer they have a relationship with, um, that's okay as long as you're not involved in that decision-making process. Capacity, again, you need to let the lawyer know if there's a capacity issue. And if they can't make a will, what happens? We're going to get into that in a second. But I've dealt with situations where, the two sisters can't agree whether or not mom has capacity to make a will. But mom does have, clearly has memory issues. She what? She's just gonna, it's very easy to suggest things and she'll just agree and do it. That sounds like that makes sense. Yeah, sure, let's do that. This is a situation where if mom wants to change her will, an appointment should be made with her lawyer, the lawyer that made her first will, the one that you're trying to change. Okay. Not you're trying to change, that mom would like to change, and that lawyer be aware of the circumstance, the fact that the two sisters aren't getting along and are both pressuring mom to make certain decisions, and that will should be drafted by that person. In a recent situation that I've been dealing with, the sister simply drafted a will for mom, invited neighbors over, and had them witness her sign it. Okay, so that will is going to be much easier to contest because there's no independent person having made an assessment of capacity. There's evidence of mom's lack of capacity. So there were, medical appointments with notes with regards to mom's ability to make decisions and her memory and things like that. And the will was not even reviewed or discussed with the lawyer. So it's very likely that the people that were involved in drafting the will, who, by the way, benefit under the will, it's very likely that that will not be deemed to be valid. If somebody cannot make a will, I didn't put it in here. I did, but I didn't. Okay, if somebody can't make a will in Manitoba, I often hear people tell me, "Oh, it goes to the government." I don't know where people have taken that from. I do not know. It is possible that it goes to the government, but it is such a remote possibility. So there's a law called the Intestate Successions Act, and it sets out quite clearly who will benefit from an estate if there is no will. It's not discretionary. It has to go in accordance with the Intestate Successions Act. So if there is a spouse and the spouse is also the parent of all of the deceased person's children, then the spouse gets everything. Okay? If there is a spouse and children, but not all of the children are children of that couple. Okay, so maybe he had a child with someone before, he had a previous spouse, or what have you. In that case, there's a minimum amount, 50,000 goes to the spouse, and then the estate is divided. Essentially, 75% to the spouse, 25% divided amongst the children. Okay, so that's the harder one. Let's assume there's no spouse, and then it all goes equally to the children. If any of the children have passed away, then it goes to the next generation, uh, to those whose parents have passed away. Um, if there are no siblings, no nieces or nephews, then it goes grandnieces and nephews. It keeps going down the line. If none of those people exists, it goes back up. Parents, if neither of the parents have survived the deceased, then it will go to their siblings. If there's no siblings, nieces and nephews, great nieces and nephews, et cetera, and it keeps going. Great grandparents, and it keeps going like this until it's clear that there is absolutely no one that can be found to benefit. And in that very limited circumstance, the proceeds of the estate can be paid into court, and it is held by the government for possible beneficiaries that might present themselves for about 100 years. And then after 100 years, if no one has presented themselves and there is no beneficiary, only at that point does it vest in the crown, does it become government property. Okay, so that's a lot of layers. So that's what happens if someone does not have a will. If someone does not have a will, and you think they really would have wanted to make these charitable gifts, or it's my best friend, she would have left everything to me, all of this stuff. It's those discussions were meant to happen before someone has capacity issues or becomes vulnerable. If you get to that point, again, of vulnerability and issues of capacity, it's very, very important to involve a lawyer and to have it done properly. Disclose all the information. Okay. So what can you do to protect your loved ones if you're a caregiver for a loved one, your client, or I guess you guys like to use your patients, and yourself? I've added a few other things in here that I haven't dealt with yet when it comes to estate planning, because I see this on occasion from the elder law side of my practice. So when we're talking about elder law, and Age and Opportunity is a good resource here, but if you feel that the person is being abused physically, emotionally, or financially, it's important to speak to them and to offer them support. Okay, give them, just let them know that you're there for them, and if that they want help, you are there to provide them with help. Okay, if they're in physical danger or if they are being robbed is not the right word. If people are stealing from them, okay, call the police. Go ahead. That's what the police is there for, to protect people from crimes, and those are crimes. I had a client uh, who has now passed away, but she was in the news and she was so proud of herself. She was living in a care facility. She had difficulty getting around, but she was fully competent and capable. And someone was stealing money out of her purse, and no one would believe her. They thought she was just this old lady that, was starting to lose it, and nobody would believe her. So she went on Amazon and she bought a teddy bear with a camera in it, and she put it next to her bed, and right in line with her purse. And sure enough, she caught healthcare providers stealing from her, and that person was fired. And this, I think it was in the Free Press and the news. And anyways, not everyone, like my client, is able to defend themselves. So if you see something that's off, speak up. If you don't think it's your place to speak up, speak to your supervisors if you have them, or to any other person that you feel would act in the person's best interest. If someone is telling you that they're being abused, I have a typo here, but you know, um, just believe them, and offer them ways that you can help them if you can. Uh, Also, if you think that the person is in danger to themselves, contact the mental health um, mobile unit, seniors mental health mobile unit. They will send a unit out to make sure that the person is safe. Um, so when people are more, uh, this isn't always the case, but as people age, they do become more vulnerable, and they're more vulnerable to abuses in their relationships. Uh, a lot of them have been responsible for someone who's now taking care of them, and feel quite a bit of guilt of calling out the abuse, or refuse to see the abuse from someone that they love, or they feel that they have nowhere to turn. And so those are all situations where just being available for them and letting them know that if they want help, uh, that you're there to provide help, is great. I've seen a lot of clients that have kids stealing from them, and they know that their kids are stealing from them, and they've tried all kinds of things, but their kids are still stealing from them. They refuse to call the police. They refuse to call the police. They do not want to see their kids in jail. Okay, they're very delicate situations, and you can only help somebody that wants help. Um, what else have I got here? If you are a family member, um, and you suspect that somebody appointed as attorney under a power of attorney document is stealing from the person or not acting in the person's best interest when it comes to finances and legal concerns, in most cases, you can make an application to court for an accounting. You can also apply to have the person removed as attorney uh, under the power of attorney. Now, the court will do this if there is evidence that the person is acting inappropriately. And that doesn't mean decisions that you think should have been made differently. We're talking about theft or clear conflicts of interest. Okay, so that avenue is available. In the meantime, most power of attorney documents do set out who can request an accounting and how. And so if the attorney is not willing to provide you with a copy of the power of attorney, then you can compel one through the courts. For healthcare providers and service people who are not family members, but also for family members, The best thing you can do is ask a lot of questions and take a lot of notes. Okay, a lot of notes of what is going on. The more notes you have, the more likely that any complaints would be taken seriously if your notes support that complaint, and vice versa. Okay, I don't know if this is what you were hoping to gain out of this presentation. Whether it is or not, I'm happy to answer any questions. And if you guys have questions that we did not present on at all, that's okay. You can shoot them my way.
Perfect. Thank you so much, Solange. So I just want to let everyone know I will now be turning off the recording. So we do have a couple minutes for questions. So if anyone would like to ask Solange anything, feel free to unmute or drop your questions in the chat. Please note that this portion of the session will not be recorded. So if you do need to leave as well, no problem at all. So yeah, feel free to unmute whenever.